Welcome to today's lecture on the influence of media trials on the right to fair trial in India, a legal and ethical perspective. Over the next hour, we shall examine how the sprawling influence of modern media, both traditional and digital, has impacted our judicial system and, most critically, the rights of citizens to receive a fair trial. Today's lecture is intended not only to provide you with a robust analytical framework for understanding these issues, but also to serve as a platform for discussions, debate, and introspection about the intersecting domains of law, journalism, and ethics. Let us begin by setting the stage with some fundamental definitions. Before delving into the legal nuances, let us first define what we mean by the term media trial. In a sense, a media trial occurs when the media, in its quest for higher viewership, readership, or online engagement, assumes the role of public prosecutor or judge. This phenomenon, often referred to as trial by media, involves extensive pre-trial media coverage that casts aspersions on an individual's guilt or innocence, often before the judicial process has had a chance to examine the evidence in a court of law. Historically, media coverage in India has evolved from media journalism, from print journalism in the colonial period to the dynamic multi-platform environment of today. With the advent of 24-hour news channels and the ubiquity of social media, the immediacy of news has often trumped caution. As we trace this evolution, consider how these shifts have altered public perceptions of justice and the foundational principles of innocent until proven guilty. Reflect for a moment on how the speed of information dissemination may conflict with the deliberate pace of our judicial process. Our discussion now moves to consider why this matters, because a fair trial is an essential pillar of democracy and human rights. Now let's transition into the constitutional and legal framework that upholds the right to a fair trial in a country. This right is embedded in our constitution primarily through Article 21, which guarantees protection of life and personal liberty, and through Article 14, which ensures equality before the law. A fair trial, as understood by our courts, is much more than the mere hearing of evidence. It is an intricate process that involves guaranteeing that all accused parties are given an unbiased opportunity to defend themselves, ensuring that the judicial process is insulated from external influences, including public opinion driven by media narratives, upholding the presumption of innocence until guilt has been conclusively established. While the freedom of expression under Article 19(1)(a) supports a free press and open discussion, the challenge arises in balancing that freedom with the need to maintain the integrity of the judicial process. In the coming parts of this lecture, we will see how this balance is both delicate and at times even contradictory. We will refer to numerous landmark cases and judicial pronouncements that have attempted to articulate this balance, shedding light on the responsibilities of both the state and the media. Let's now move into a deeper exploration of our legal and constitutional dimensions. Let's do a detailed examination of constitutional provisions. Within the Indian Constitution framework, several articles provide the basis for both the right to fair trial and media freedom. Let's explore these in detail. Article 21 safeguards an individual's life and personal liberty, emphasizing that no one can be deprived of these rights except through a procedure established by law. Interpretations by the judiciary have reinforced that these procedures must be fair, transparent, and free from bias. Article 14 establishes the principle of equality before the law. For the accused, this means that irrespective of social, political, or economic background, they deserve equal protection and an impartial trial. Article 19(1)(a) champions free speech. It also introduces complexity when the freedom results in potentially prejudicial media commentary. The interplay between the right to free expression and the need for justice becomes a focal point of discussion. Few judicial decisions have outlined the extent to which media coverage can imagine up to impinge upon these rights and have delineated limits for free expression when it comes to preserving judicial impartiality. Let's talk about judicial philosophy and court's opinion. In this section, I would like to focus on how our judiciary has grappled with the challenges posed by media interference, particularly in cases that have attracted intense public attention. Through a series of judicial pronouncements and legal interventions, the Supreme Court of India has attempted to strike a fine balance between upholding the freedom of the press and safeguarding the right of a free trial. Let's begin by revisiting a recurring theme in Supreme Court's jurisprudence, the strong disapproval of what is often termed as trial by media. This phrase itself reflects the concern that media coverage, particularly when speculative, emotionally charged, or preemptive, can disrupt the impartial adjudication of justice. In the Sahara India Real Estate Corp Limited versus SEBI, the court acknowledged that while the media plays a vital role in democracy, there must be a mechanism to postpone reporting of sub judice matters in extreme cases to prevent prejudice. The court introduced the concept of postponement orders to temporarily restrain media from publishing content likely to affect the fairness of the trial. It was a landmark judgment in that it established a doctrine of proportionality between freedom of expression under Article 19(1)(a) and the right to fair trial under Article 21. Similarly, in Ramesh Thapar versus State of Madras, a 1950 case, while the court upheld the importance of a free press, it emphasized that such freedom cannot be unregulated when it infringes upon the administration of justice. Another significant movement came in R.K. Anand versus Registrar at Delhi High Court, a 2009 case, where the court initiated contempt proceedings against senior lawyers whose conduct, brought to light by a media sting, had the potential to derail judicial proceedings. Interestingly, while the media's role was not penalized, the case drew attention to how the boundaries of investigative journalism must be defined carefully, especially when judicial matters are involved. In Arun Shourie and others versus Supreme Court of India, 2021 case, the court took up a petition challenging the contempt law itself, particularly Section 2CI of the Contempt of Courts Act 1971. While no changes were ultimately made, the dialogue highlighted the inherent tension between accountability of the judiciary and media's role in questioning or reporting on judicial conduct. Through such cases, the judiciary has reiterated that the sanctity of the courtroom must be preserved. The justice delivery mechanism cannot function effectively if public discourse fueled by speculative media narratives starts influencing witnesses, altering public perception of the accused, or pressurizing judges under the glare of public sentiment. Judges have consistently stated that courts must be allowed to function as neutral, insulated forums where decisions are made on evidence, not emotions or optics. Let's take a moment to reflect on the delicate balance being attempted here. On one hand, we have a constitutional obligation to uphold a vibrant free press, a watchdog that brings injustice to light and questions power. On the other hand, the same constitutional framework demands that every individual, regardless of public opinion, deserves a fair, impartial, and dignified trial. The courts are not opposed to criticism, nor do they wish to stifle the press, but what they advocate for is responsibility, restraint, and reverence for process, particularly when the stakes are high and emotions are running strong. As we will explore in comparative legal segments later in this lecture, this friction is not unique to India. Across democracies, courts and lawmakers are wrestling with similar dilemmas: how to protect the foundations of justice without muzzling public discourse. In the Indian context, however, our solutions must be rooted in our constitutional ethos, our social realities, and the evolving nature of our media ecosystem, which now includes not just print and broadcast, but viral digital platforms with unregulated narratives. Therefore, the role of judiciary as a custodian of justice and a moderator of constitutional freedoms becomes even more vital. Let's keep one question in mind: where should the line be drawn and who should draw it? Should it be the judiciary, the legislature, the media houses themselves, or a collaborative framework that includes all stakeholders? Let's carry this question into the upcoming comparative discussions and reform recommendations, for it may hold the key to resolving this tension, not just theoretically, but practically, sustainably, and justly. Expounding further on the legal doctrines that govern the intersection of media and the judiciary, it is essential to grasp the underlying principles that shape the regulatory framework. These doctrines, though rooted in precedent, have evolved and continue to adapt to modern media realities, particularly the rise of instant and widespread digital dissemination. The doctrine of sub judice, which means under judgment, is intended to preserve the integrity of ongoing legal proceedings. When a matter is before the court, it should not be subjected to public commentary that could influence the judge or the jury, contaminate witness testimony, or build societal pressure that skews the outcome. In India, this principle finds indirect expression in Article 19(2) of the Constitution, which allows reasonable restrictions on free press, free speech, in the interest of administration of justice. A relevant example is the case of Kumar Gupta versus B.K. Sen, a 1961 case, where the Supreme Court warned against publications that suggest someone is guilty before the court has ruled. The court emphasized that such publications could interfere with justice delivery system and thereby violate the sub judice rule. The Contempt of Courts Act 1971 is the principal statutory instrument for maintaining respect for the judiciary. It classifies contempt into civil and criminal, with the latter including acts that scandalize or lower the authority of the court, prejudice or interfere with judicial proceedings, or obstruct the administration of justice. Cases such as Arundhati Roy's contempt proceedings of 2002 and more recently, Prashant Bhushan's conviction in 2020 demonstrate how the law has been invoked to delineate the permissible limits of criticism. While the judiciary has emphasized that criticism per se is not contempt, when comments undermine the authority of the court or are made during active proceedings in a prejudicial tone, contempt jurisdiction may be exercised. Importantly, in the context of media trials, criminal contempt becomes relevant when news channels or social media users attempt to run parallel trials that imply guilt or innocence, pressurize the court, or influence witnesses. In addition to statutes, judicial pronouncements and regulatory guidelines have served as informal guardrails for media trial. In the Sahara India Real Estate Corp Limited versus SEBI 2012 case, the Supreme Court laid the groundwork for postponement orders, allowing temporary restraints on reporting in extreme cases to prevent trial prejudice. While the court was cautious not to impose blanket bans, it acknowledged that the media influence can be dangerous in high-profile matters. Moreover, the Press Council of India has issued numerous ethical guidelines for journalists, including the advisory to refrain from publishing anything that could prejudge the guilt or innocence of an accused. Yet these guidelines lack binding force and enforcement remains weak in the digital era, where many platforms operate outside the ambit of the PCI. Further, in the Manu Sharma versus State of Delhi case 2010, which dealt with the Jessica Lal murder trial, the court noted the intense media glare and reiterated that media should not assume the role of an investigator or adjudicator. It recognized that while media can be a catalyst for justice, it must operate within the bounds of the restraint. Despite these doctrines and instruments, enforcement has remained a challenge, especially with the proliferation of digital platforms, the rapid cycle of news, and the competitive need for sensational headlines. Many new age media players are not governed by traditional journalistic ethics or regulatory oversight, complicating the landscape. As we delve deeper into these doctrines, it becomes clear that our legal system is in a phase of transition. What once applied to print and television now must be reinterpreted for social media, YouTube channels, and viral WhatsApp forwards. In this evolving scenario, legal doctrines must remain dynamic and enforcement must become more agile. The conversation, therefore, is not just about reinforcing existing laws, but about reimagining them for a new era. An era in which the lines between news, opinion, and influence are blurred, and where judicial integrity must be protected not just in courts, but across the vast, chaotic, and unregulated landscape of modern information flow. This segment lays the legal foundation for understanding how media can be regulated without infringing upon democratic freedoms and sets the stage for our upcoming conversation on institutional reforms, comparative insights, and actionable solutions. Having examined the legal foundations and judicial perspectives, let us now turn our attention to the very real impact that media trials have on legal proceedings themselves. Let's discuss media trials and prejudicial publicity, which is a threat to the presumption of innocence. In a democracy governed by the rule of law, the courtroom, not the newsroom, is where justice must be delivered. And what happens when headlines become judgments and social media posts become verdicts? Today, we confront a deeply uncomfortable truth. Media trials often erode justice before the court even begins. Let's start with the mechanism. Prejudicial publicity is not just coverage. It is a coverage that taints. It is a storytelling that poisons the well. It begins with sensational headlines. Murder on the loose, shocking details revealed, he did it, we have a proof. These aren't just headlines. They are narratives, weapons that shape public opinion before the law has had a chance to speak. The media, in its quest for virality, often engages in selective reporting, cherry-picking facts, leaking accusations, and publishing unverified scoops that bypass due process entirely. This leads to something even more dangerous: societal conviction. The accused, whether a public figure or a common citizen, becomes guilty in the court of public opinion. When this happens, we lose something foundational, the presumption of innocence. In Indian law, and indeed in every just legal system, an accused is presumed innocent until proven guilty beyond reasonable doubt. But in a media trial, the opposite becomes the truth. People say, why would they arrest him if he wasn't guilty? It's all over the news, he must have done something. This presumption of guilt becomes a societal default, and it pressurizes investigators, prosecutors, and even judges. Public outrage starts dictating outcomes. This is not justice, it is a mob rule in digital disguise. Let's now address the new battlefield, digital media. In the age of WhatsApp forwards, Instagram stories, and trending hashtags, everyone has become a broadcaster, but not everyone has a burden of ethics. Platforms like Twitter, Facebook, and YouTube are fertile grounds for prejudicial narratives. Unverified CCTV footage, personal photos, private chats, all leaked and consumed in seconds. Let's take a contemporary example. Within hours of newsbreaking, hundreds of tweets proclaimed guilt, anonymous YouTube videos claimed to have insider facts, WhatsApp groups forwarding doctored screenshots, and television debates ran with hashtags like justice for XYZ even before a charge sheet has been filed. Statistically, such cases reach millions within hours, far exceeding the reach of judicial proceedings. This doesn't just affect the accused, it can bias witnesses who now feel complicated to match public opinion. Advocates and attorneys who may change their arguments to fit media narratives, and even judges who, while trained to be neutral, cannot exist in a vacuum. Beyond the trial, we often underestimate the personal fallout of media trials. For the accused, social ostracism, suspension or termination from employment, harassment of family, mental health, deterioration, stigma that follows for life even if they are acquitted. Let's be very clear, acquittal does not undo defamation. The stain of public judgment doesn't fade with a verdict. We must ask, who pays the price for trial by media when the courts find them innocent? So what's the way forward? The law is meant to be measured, patient and fair. Media, when it acts irresponsibly, undermines this foundation. This is not a call to silence the press. A free press is the cornerstone of democracy, but freedom must walk hand in hand with responsibility. What we need is stronger guidelines on media conduct during ongoing trials, stricter penalties for unverified leaks, and most importantly, legal awareness among citizens so that we do not mistake headlines for evidence. Let the media inform, but let the courts decide. Let's analyze the effects on legal proceedings of when media narratives enter the courtroom. In theory, Indian courts operate in an insulated bubble, free from influence, guided solely by statutes, precedents, and facts. But in reality, courts do not exist in a vacuum. Judges are also human. They read newspapers, they scroll social media, and they are not immune to the overwhelming echo chambers created by public discourse. Prejudicial publicity creates an invisible pressure. It sets expectations, frames the story in black and white, and often villainizes or glorifies individuals long before legal arguments are heard. The judiciary, though fiercely independent in its structure, may absorb these currents unconsciously. We must ask, can a judge truly remain unaffected by a narrative that has been repeated 1,000 times outside the court? The danger of prejudicial publicity is not limited to influencing judicial psychology. It extends to the courtroom itself, especially the way evidence is presented, perceived, and debated. Media narratives often simplify complex evidence into emotionally charged headlines. What should be a fact-based assessment becomes a story arc. The evil accused, the innocent victim, the heroic prosecution, or a biased system. This framing affects how lawyers construct their arguments. Defense lawyers are often forced to spend valuable time battling public perception, not just legal points. Judges may ask more probing questions on media highlighted evidence, even when such focus may not align with legal relevance. We have seen this in trials where CCTV footage, witness statements, or forensic findings were taken out of context by the media, creating irreversible damage before the facts could be legally dissected. In high-profile cases, excessive media attention can paradoxically slow the wheels of justice. How? Because of the stakes involved in public image management. Prosecution often delays charge sheets to ensure airtight narratives. Defense may request adjournments to cool public tempers. Courts may defer hearings, anticipating quieter atmosphere for fair trials. The result: pretrial detentions extend Accused individuals suffer prolonged reputational and personal damage. Key witnesses may disappear or change statements. Public interest fizzles out, leaving behind a fractured judicial process. This is not just a matter of delay, it is a direct attack on the constitutional principle of speedy justice under Article 21 of the Indian Constitution. Let's discuss the role of social media in public engagement with the age of hashtag justice. Let's discuss speed versus accuracy. Digital platforms have rewritten the rules of journalism. What used to be a 24 hours news cycle is now a 60-second one. The incentive is speed, not depth. Platforms reward viral content, not verified content, and this trade-off has devastating consequences for legal integrity. A video clip without context, a leaked with audio without verification, a WhatsApp forward dressed as breaking news. All of this rapidly becomes the dominant story, repeated across thousands of screens. In legal matters, this premature storytelling is dangerous. It can ignite communal tensions, lead to targeted harassment, and alter the directions of investigations before they even begin. Citizen journalism and viral narrative social media empowers citizens to speak truth to power, but it also empowers mobs to become self-declared courts. A user with no legal training or verified facts can go viral with a thread labeling someone as a rapist, forcer, or murderer. Millions engage, news channels pick it up. Lawyers and judges suddenly find themselves reacting not to evidence but to an atmosphere. This is the democratization of defamation, and it is as powerful as it is uncontrolled. But it's not all bleak. The same platforms have exposed miscarriages of justice, given voice to the voiceless, and held powerful institutions accountable. So the dilemma remains, how do we protect the court from disruption while preserving free speech? Now that we have examined both the mechanics and the effects of prejudicial publicity, we shall turn our focus to real-world cases that exemplify these challenges. Let's have an analysis of landmark cases. Case studies provide us with concrete examples of theory in action, a way to see how the interplay of media narratives and judicial processes unfolds in real-life scenarios. In this portion of our lecture, we will delve into several landmark cases that not only highlight the influence of media trials but also expose both the benefits and pitfalls of intense media scrutiny on legal proceedings. First is the Arushi Talwar case. Let's begin with the Arushi Talwar case. This case, one of the most highly publicized in recent memory, demonstrates the complex dynamics that ensure when media coverage becomes pervasive and speculative. Pervasiveness and speculative reporting from the outset. Media outlets across the country reported on the case almost in real time. Headlines often speculated on the guilt of the accused without waiting for comprehensive investigation results. This speculative nature meant that the media was, in effect, crafting a narrative that frequently bypassed the factual intricacies of the case. The long-lasting impact of these media narratives raised questions about whether such early speculation tainted public sentiment and potentially influenced later judicial process. As we consider this case, let's reflect on how unverified media reporting might prejudice a case long before all the evidence is subjected to judicial scrutiny. Moving on, we examine the Jessica Lal murder case, a case that exemplifies the dual-edged sword of media activism. Media activism and its dual nature. Initially, the media's relentless focus on the case did generate public outrage and contributed to widespread demands for justice. In this instance, media coverage played a constructive role by ensuring that the case did not fade from public consciousness, ultimately leading to a reopening of the investigation. On the positive side, the media's intervention galvanized public opinion and spurred action that had been lacking in the initial phases of the investigation. However, the same intense scrutiny also brought about negative consequences. The focus on dramatic headlines sometimes overshadowed the factual details, compromising the balance needed for an unbiased trial. Repeated media pressure led to interruptions in the natural course of investigation, potentially influencing the judicial process. We will analyze how while media activism ensured that justice was eventually pursued, it also risked undermining the fairness of the trial by promoting a narrative of public judgment rather than judicial determination. Let's reflect on whether the positive outcomes justify the means employed by the media. Next, let's consider the Sushant Singh investigation, one of the more recent examples that clearly illustrates the transformational role of digital media. With the ubiquity of social media platforms, the narrative around this case spread rapidly and polarizing opinions emerged almost instantaneously. Platforms such as Twitter, Facebook, and Instagram became battlegrounds for conflicting narratives, with each side presenting their version of events, shifts in narratives across platforms. Initially, the story was driven by snippets of information and unverified reports. As opinions solidified, hashtags, viral posts, and even memes contributed to a highly polarized public discourse. The digital forward not only complicated the investigative process, but also raised questions about impartiality of subsequent legal proceedings. This case offers a vivid illustration of how digital media can create an environment where public opinion is already divided, even before the full set of evidence is presented in court. Now we should discuss to what extent does digital media deepen the polarization of public opinion, and how might this affect the objectivity of judicial decisions. Beyond these major cases, there are several additional instances where media commentary has had a notable impact on legal proceedings, although we will discuss these briefly. There have been cases where the judiciary has had to intervene due to highly sensationalized media coverage. Such interventions may include issuing restraining orders against media speculations or initiating contempt proceedings against entities that cross ethical boundaries. In some cases, the media's role in fueling public debate has drawn sharp criticism from both legal experts and civil rights advocates. These cases serve as reminders of the complex balance between necessary transparency in public affairs and the risk of undermining the fairness of judicial processes. While these cases may not have the notoriety of Arushi, Jessica Lal, or Sushant, they collectively underscore the broader challenge. How does society balance the media's role in keeping the public informed against its potential to prejudice legal outcomes? As we have considered each of these case studies, I invite you all to reflect on the following question. How can we balance the media's duty to highlight possible miscarriage of justice with the equally important need to preserve the sanctity and fairness of judicial outcomes and proceedings? In what ways might early and unverified reporting impact on individuals' right to an impartial trial, even if the media subsequently clarifies its initial positions? Are there proactive measures that could be implemented by courts and media organizations to mitigate the negative effects witnessed in these cases? Let's explore these one by one. First is balance of media roles. Balancing the media's duty to inform and its responsibility to the judiciary, the media plays two crucial roles: acting as a watchdog to expose potentially miscarriage of justice and informing the public about ongoing legal matters. To maintain a balance, media organizations must adhere strictly to ethical journalism practices, ensuring that their reporting is accurate, substantiated, and presented in a neutral tone. Media outlets can implement and follow stringent internal guidelines, such as these recommended by the Press Council of India, which outline the limits of speculative or prejudicial reporting on the judicial process. Such guidelines help ensure that while the media remains vigilant, it does not overstep into influencing judicial outcomes through bias. Courts can contribute to this balance by issuing clear directions to the media during sensitive phases of litigation. This, in combination with regulatory bodies overseeing ethical journalism, helps to protect the sanctity of judicial process while still allowing the media to fulfill its role of public oversight. How can collaboration be done and dialogue be promoted? Promoting regular dialogue between media professionals and the legal community can foster a better understanding of each other's challenges and responsibilities. Joint workshops or seminars can help develop best practices that protect the right to a fair trial while ensuring transparency and accountability. 2. Impact on the accused. Consequences of early and unverified reporting. Prejudice and presumption of innocence. When media reports prematurely or without full verification, the accused may face a public presumption of guilt. This is problematic because the principle of innocence, while until proven guilty, is a cornerstone of judicial system. Early narratives can cement a bias that persists even if the media later issues corrections or clarifications. Unverified reporting can tarnish an individual's reputation irrevocably. The accused might suffer damage to personal relationships, career prospects, and overall social standing, regardless of later judicial findings. The stigma from premature judgment can be difficult to reverse, as public perception needs to be slow in correcting initial impressions. Public opinion shaped by early reporting may seep into courtroom dynamics, affecting judges, witness perception, even the demeanor of legal representatives. Judges and legal practitioners might feel indirect pressure from a highly charged media environment, potentially complicating an impartial legal process. In high-profile cases, the sheer volume of unverified information spreads quickly and widely, amplifying the damage The accused, despite their right to a fair trial, might then have to spend significant resources on reputation management, detracting from their ability to mount a robust defense. Let's talk about the preventive measures and mitigating the negative effects of media trials. Courts can issue specific orders that temporarily restrict certain types of media reporting during sensitive phases of trial. Clear written guidelines for media coverage during sub judice periods can help curb sensationalism and provide a framework for responsible reporting. Regulatory bodies like the Press Council of India can be empowered to enforce ethical standards more rigorously. Establishing a formal review mechanism that audits high profile cases may discourage premature or biased reporting. Sanctions for non compliance could also be considered. Training and workshops for journalists. Proactive measures include dedicated training for journalists on legal literacy and the nuances of reporting on ongoing judicial processes. When media professionals understand the potential ramifications of their reporting on an accused's right to a fair trial, they are more likely to exercise caution. Developing and adopting fact checking protocols and real time verification systems can help media houses ensure the accuracy of their reports. This is particularly relevant in the era of social media, where misinformation can spread rapidly. Collaborative efforts between fact checking organizations and media outlets can act as a buffer against the spread of unverified information. In cases where the risk of prejudicial reporting is high, courts could encourage the use of mediated platforms, such as officially sanctioned live updates or press briefings, which provide verified details about the case. This approach can help reduce the information vacuum that often leads to speculation. Media organizations themselves can foster a culture of self-regulation by setting up internal review boards and editorial oversight committees to scrutinize coverage, particularly in sensitive cases. Peer reviews and accountability within the industry can contribute to a more reasonable approach. Let's summarize all this, striking an optimal balance between the media's responsibility to keep the public informed and ensuring the fairness of judicial proceedings require a multi-pronged approach. It involves cultivating ethical journalism, enforcing judicial legal oversight, adopting proactive verification measures, and fostering a constructive dialogue between the legal and media communities. By addressing early unverified reporting and mitigating its adverse impact on the accused, through these preventive measures, society can work towards preserving both the freedom of the press and the sanctity of the judicial process. These reflections are critical as we aim to understand the broader legal and ethical implications of media trials. The case studies not only serve as cautionary tales but also provide valuable insights into potentially path for reform and greater judicial integrity. As we move beyond the case studies, it is crucial to recognize the authoritative voice of our judiciary. The courts play an instrumental role in setting the boundaries for acceptable media conduct during ongoing legal proceedings. In this section, we will dissect three significant areas. First is Supreme Court observations. Several landmark cases, pronouncements by the Supreme Court have underscored the importance of caution in media reporting. The Apex Court has repeatedly highlighted that while freedom of speech is cherished right under Article 19(1)(a) of the Constitution, it must not be exercised in a manner that undermines the right of a fair trial. Consider, for instance, how the court in various judgments has admonished the media for engaging in speculative reporting that might preempt judicial conclusions when the court states the presumption of innocence is not just a legal principle, but a safeguard for a free and unbiased trial. It underscores the judiciary's concern that premature media declaration can create an irreversible public bias. The implications of such observations are far-reaching. They remind the media that their role does not extend to acting as a court of public opinion. Instead, the media should serve as a conduit for verified information while respecting the confidentiality and integrity of the judicial process. These judicial reminders, while commendable, also present a challenge, ensuring that these warnings are heeded by all media entities, especially in an era of rapid social media dissemination. Another central element in the judicial arsenal is the enforcement of the sub judice principle. This principle mandates that any comment or analysis concerning the merits of an ongoing trial must be avoided until a trial is concluded. The courts have issued several orders instructing media outlets to refrain from commentary that could be prejudicial. By emphasizing the need for silence or cautious reporting during active litigation, the judiciary is reinforcing the idea that any form of commentary that could influence the evidentiary process is not acceptable. So, what are the implementation challenges? While these directives have been clearly laid out in several judgments, their implementation is far from uniform. Some media organizations adhere strictly, ensuring that their coverage remains within the prescribed bounds. However, there have been notable instances where these directives have been ignored or only partially followed, leading to public outcry and, in some cases, judicial interventions. This raises several questions. What mechanism can be put in place to enhance compliance with the sub judice principle? Should there be a more robust monitoring of media commentary during crucial phases of a trial? As we discuss these issues, consider how a balance may be struck between open public discourse and the sanctity of judicial proceedings. Finally, we examine contempt proceedings, an important judicial tool used when media conduct is seen as interfering with the administration of justice. The Contempt of Courts Act 1971 provides for actions against individuals or entities that publish material which may potentially undermine a fair trial. The rationale is straightforward: to safeguard the integrity of judicial process by imposing consequences on those who overstep their bounds in reporting. When contempt proceedings are initiated, it is not merely a punitive measure. Rather, it is a corrective step aimed at restoring the balance between free expression and the right to a fair trial. Such proceedings serve as an important reminder that while the media is free to report, it is not free to disrupt the judicial process. For example, in several high-profile cases, the judiciary has not hesitated to issue contempt notices against those whose reporting was deemed to have a prejudicial effect. Let's consider the broader implications. Contempt actions, if overused, might be seen as a threat to freedom of the press. Thus, it is vital that the rationale behind each contempt proceeding is transparent, proportional, and in strict adherence to the due process. Let's reflect on how these actions can be balanced to ensure that they protect the judicial process without becoming a tool of censorship. As we analyze these judicial responses, the observations of the Supreme Court, the enforcement of the sub judice principle, and the rationale behind contempt proceedings, it is essential for us to pause and consider ways in which these measures might be strengthened. How can judicial mechanism be refined to offer better protections for the sanctity of the trial without unduly curtailing the media's freedom of expression? Such reflections are critical as we continue our dialogue on the challenges facing our legal system in this digital age. The goal is to forge a path that honors both the right to a free press and the imperative of an impartial and fair judicial process. Having reviewed concrete cases alongside judicial guidance, we now shift our focus to the ethical underpinnings and regulatory gaps that allow media trials to flourish. In the realm of journalism, ethical standards are paramount. In this segment, we will cover three such essential dimensions. 1. Core principles of responsible reporting. First, let's delve into the core principles that form the backbone of ethical journalism: accuracy, fairness, and accountability. Accuracy is the foremost pillar of responsible reporting. It requires that every fact, figure, or statement published be verified before it reaches the public. In the context of legal proceedings, errors can lead to misinterpretations that not only tarnish reputations but also potentially influence judicial outcomes.